Okay. Okay. Good afternoon. Thanks, everyone, for joining us. My name is Adam Aronson, and I am a professor of history and the chair of the history department here at Manhattan College. We are here for the Robert J. Christen Program in Early American History and Culture, which was founded in 1986 to honor the memory of Dr. Robert Christen, who died in March of 1981. He was an esteemed educator and public servant who began his long association with Manhattan College as a Manhattan prep student, and then was an undergraduate in the School of Arts, graduating in 1952. As a student, he was a seeker, a meticulous worker, a curious and challenging participant in all of his classes, and a notable man about campus. He joined the faculty of Manhattan College in 1958. Yes, that's 6 years after he graduated as an undergraduate. As a teacher, he was exacting but fair from each student his or her full potential. Dr. Christen earned a master's degree before starting here and a PhD after from Columbia University. As a scholar, he was a specialist in the colonial and revolutionary periods of American history. He wrote a doctoral thesis on Isaac Sears, a radical New York City patriot during the American Revolution. At Manhattan, he was one of the founders of Patriotism in Terrace, or what we call Peace Studies now, an institute whose goal was to make the study of peace as serious a subject in academia as the study of war. His energies were not confined to campus. He was an active member of the American Civil Liberties Union, where he served on the Committee for Academic Freedom, as well as the AAUP. He was a member of the local school board, District 10 in the Bronx, and he was appointed to the New York City Board of Education. He was elected the president of that group in 1976 and chaired the Committee for Collective Negotiations with the Teachers Union in the New York City school system. Because of his many contributions to education, Riverdale's Public School number 81 is named in his honor. We've had these lectures roughly every 2 years since 1986, and it's our great honor to have Congressman Jamie Raskin as our lecturer today. Congressman Raskin is representative for Maryland's 8th District and the ranking member of the House Committee on Oversight. Before his election to Congress, Raskin was a constitutional law professor at American University, Washington College of Law. He served as the lead House manager in the second Senate impeachment trial for Donald Trump, which ended with a 57-43 vote to convict the president for inciting a violent insurrection against the Constitution. Raskin also served on the Select Committee to investigate the January 6th attack on the U.S. Capitol. He's the author of several books, including the New York Times #1 bestseller, Unthinkable: Trauma, Truth, and the Trials of American Democracy, published in 2022. Jamie's book, We the Students, was recently banned in the state of Texas. And in the same week, Vladimir Putin banned him from Russia for life for his pro-Ukraine activities. So those are things he wanted me to add, so I did. It's a pleasure to have you, and we look forward to hearing from you today.
Well, Adam, thank you very kindly for that wonderful introduction, and I'm delighted to be here at Manhattan College, where I've never been before, and I'm delighted to be part of the Robert Christen lecture series, and I think my friend Kate Christen, who I've known since the middle of the 20th century. I think that she had something to do with it, so thank you, Kate, for inviting me, and the whole Christen family, including Kate's son, Nico, who's worked with me in my Democracy Summer project in the summer, which gives me the opportunity to plug, and for high school and college kids. Well, Kate said, well, when you come, just give them all your wisdom about the Constitution. And I had to laugh when she said that, because I had one other invitation like that once to go to the Supreme Court. Justice Kennedy had invited me to come and talk about this book that you kindly mentioned was censored in Texas recently, We the Students. And the book was sponsored by the Supreme Court's Historical Society, and so they invited me to come. And so I told my wife, Sarah, I said, you got to come to the Supreme Court. The justices are going to be there. The clerks are going to be there. And Justice Kennedy invited me to give all my wisdom about the Constitution. So she decided to come, and she never goes anywhere with me, but she said she would come. So she went, and then I gave my whole little thing about we the students and the history of the Supreme Court's treatment of kids in public schools. And then I retired to what I thought was more than polite applause when it was all over, but I turned to Sarah and I said, so what do you think? She said, well, I don't know how much wiser they are, but they're definitely older. And you notice Sarah's not here today. But anyway, but my topic is constitutional fallacies and constitutional patriotism. In the age of propaganda and disinformation and big lies that we live in, constitutional fallacies and constitutional dogma are replete in our society and have actually come to really infiltrate legal discourse, constitutional discourse, Supreme Court decisions even. And so I wanted to try to, obviously I'm not going to be able to confront all of them today, but I thought I would take a couple of constitutional fallacies that are quite current in our life, which are occasioning a lot of harm in our society, I think, and to look at them and then to discuss the antidote, I think, to all of these fallacies and all of this propaganda, which is constitutional patriotism. And then we get to open it up for conversation, right, and Q&A. So that's my game plan here. The Constitution is our governing social contract and social covenant. I was one time invited to go on the O'Reilly Factor show. I don't know if you know that one, with Mr. O'Reilly. And the occasion for that was that the Ninth Circuit Court of Appeals had ruled in a case called United States versus Newdow that it violated the Establishment Clause to conduct the Pledge of Allegiance in elementary school classrooms with the words, one nation under God in them. And the guy who brought the lawsuit, his name was Michael Newdow, and he was a doctor, a lawyer, and an atheist. So he's a triple threat, okay? And he said he wanted his kids to participate in the Pledge of Allegiance because under West Virginia versus Barnett, you don't have to participate if you don't want to, but he wanted his kids to participate, but he wanted them to participate in the original Pledge of Allegiance written by Francis Bellamy, the abolitionist Vermont minister who wrote the Declaration after the Civil War when there were continuing Confederate battle flag salutes and ceremonies in the South. And the way he wrote it, it was a very strong pro-union statement and against what was taking place in the South. And it said, I pledge allegiance to my flag of the United States of America and to the republic for which it stands, one nation, indivisible, very sharp word, with liberty and justice for all. And so there was no mention of God in it. And so anyway, he said he wanted his kids to participate in that Pledge of Allegiance and that it violated the Establishment Clause when Congress, several weeks after the Supreme Court's decision in Brown versus Board of Education, added the words one nation under God to the original Pledge of Allegiance. So anyway, this Ninth Circuit Court of Appeals panel, which was made up of two Democratic appointees, or rather two Republican appointees and one Democratic appointee, they struck down that phrase saying that it was an endorsement of monotheism, it was an endorsement of religion, and it failed the Supreme Court's test in Lemon v. Kurtzman. Anyway, so I got invited. This was before I was in politics, obviously. You'll be able to tell from the story. I was invited to come and just talk about the First Amendment and this whole controversy on the O'Reilly show. And at that point, I was an innocent because I never seen the O'Reilly factor, so I didn't know what I was getting into. But anyway, so I got there, and then he launches into this whole thing about these crazy judges and so on. And, he says, if we're not going to be one nation under God, what are we? And I said, well, I think if you're an originalist, as you are, you would go back to the original Pledge of Allegiance, which, that would certainly be an acceptable alternative, given the Ninth Circuit Court's ruling, which later was reversed by the Supreme Court on lack of standing grounds. But anyway, he kept pressing the point. He kept saying, well, if we're not one nation under God, then what are we? And I said, I don't know. How about one nation under Canada? Right? That'd be like geographically correct, or we could be one nation under the Constitution, which is what we really are, because we're not one religion and we're not one political party, we're not one race or ethnicity, but we do have one Constitution. And if we got to be under something, I think it's under the constitutional framework and under our constitutional values. So anyway, that was the last time I made it onto the O'Reilly Factor show. But that story I wanted to tell you because I wanted to talk about, I probably should have asked somebody how to work this before I did it, but what I want to talk about is the Constitution as our social contract and where we are with the Second Amendment. Because the whole purpose of a social contract, if you read, and I don't know if they still read anymore, but if any of you students are reading the social contract theorists like Hobbes and Locke and Rousseau, but the basic theory is that you will be safer within society, within the social contract, than you would be staying outside of it in what Hobbes called the state of nature, which he likened to a state of war. And so we give up our rights of vengeance and retribution and violent self-defense in return for the regulation of civil society, and then we actually become freer by entering civil society than we would be if we stay outside of it. Well, how are we doing in terms of social contract? Let's see. Wait. I'm not sure how to work. Let's see. There we go. America's an outlier in terms of gun violence all over the world. We have a rate of gun violence 25 times higher than the European Union countries do. And it's just not comparable to, to what happens in Canada. It's not comparable to what happens in Japan, where they tend to have 3 or 4 gun-related homicides a year. Some countries have 0 gun-related homicides a year. Some have 1 or 2. I just pulled down the 2023 numbers. So we had more than 18,000 people, 18,854 people killed, 36 injured, young people. Gun violence is now the leading cause of death for people under 18 in America, much bigger than any disease, much bigger than auto accidents. Nothing comes close. We pulled here's the New York numbers. I thought you'd be interested in seeing those. Last year, 422 people killed, 1,500 so basically, this was a statement that the government continues to have the right to assemble in, Lafayette Square, and to make noise, but not at 2:30 in the morning right in front of the White House, because people are sleeping inside, so that well, the gun debate in America should take account of what the Constitution really is, as Justice Scalia articulated in the Heller decision. That is, there's nothing in the Second Amendment that compels us to live in the House. Thoughts and prayers, because you wouldn't want to waste too much time on it. And then they say, but there's nothing we can do about it because the Second Amendment gives the people the right to have AR-15s, assault weapons, whatever they want. Okay? Now, I've brought very specific quotations from very specific members because I don't want you to think that I'm making this up in any way, okay? Because they've adopted what I call the insurrectionist theory of the Second Amendment. So here's my colleague Matt Gaetz. The Second Amendment is not about hunting, recreation, or sports. The Second Amendment is about the ability to maintain within the citizenry an armed rebellion against the government, if that becomes necessary. I hope it never does. A nice touch there. Here's Chip Roy, my colleague from Texas, who's probably the best constitutional lawyer they've got on this, and I've tried to engage him numerous times in debate on this subject. He says, a semi-automatic is a weapon that you can use for self-defense. It's a semi-automatic weapon that you can use to defend yourself against home invaders, but also, let's be clear, against tyranny. The very existence of the Second Amendment is designed purposefully to empower the people to be able to resist the force of tyranny used against them, to step over their natural rights given to them by God. That is why the Second Amendment exists. That is very specifically why the Second Amendment exists. Let's be very clear about that. Okay, so just to get the theory straight, the people have to have the power to militarily oppose tyranny in the government if the government is to turn tyrannical, which means the people, of course, must have an arsenal equal in firepower to that of the government. So if the government or the National Guard has assault weapons, then the people have to have assault weapons if the people are going to overthrow the government. And in theory, the logic of that extends to tanks or B-52s or theoretically nuclear weapons, but I can't get them to comment on that. But here's Marjorie Taylor Greene. Democrats, they hate our Second Amendment because ultimately the truth is it's our Second Amendment rights, our right to bear arms, that protects Americans and give us the ability to defend ourselves from a tyrannical government. Here's my friend. Sometimes this works for me, sometimes it doesn't. Lauren Boebert. Second Amendment has nothing to do with hunting, says Lauren, unless you're talking about hunting tyrants. Maybe, okay. I'm not talking about like one offhand remark. I'm talking to you about the core theory of the Second Amendment, okay? Here's Ted Cruz. The Second Amendment isn't for just protecting hunting rights, and it's not only to safeguard your right to target practice, it's a constitutional right to protect your children, your family, your home, our lives, and to serve as the ultimate check against governmental tyranny. The ultimate check, okay. Now, I think I've got one or two more.
The arrows might work better.
Yeah, I'm trying the arrows. Oh, I see. Let's see. Okay. So this comes from the National Rifle Association and the so-called gun rights movement. It is basic constitutional dogma for them. Larry Pratt, Gun Owners of America. The Second Amendment is for restraining tyrannical tendencies in government, if need be, by active measures. Wayne LaPierre, CEO of the NRA, who's been found guilty recently of converting some of the resources of the hard-earned dollars of the members of the NRA for some personal purposes. He says, it doesn't matter to them that the semi-auto ban gives jackbooted government thugs more power to take away our constitutional rights, break in our doors, seize our guns, destroy our property, and even injure or kill us. Okay. So, I just want to show you how to debunk the insurrectionary theory of the Second Amendment in the Constitution. Okay? It is not difficult at all, and you don't even really need to cite Supreme Court precedent. I mean, the Supreme Court has not really pronounced on this, although I think that all of the cases during the Civil War rejecting the South's right to engage in insurrection and secession are sufficient refutation. But let's just in order to press insurrections. Now, is it plausible that the Constitution in one place establishes the right to engage in insurrection and then also gives Congress the power to put an insurrection down? Check out the Republican Guarantee Clause, which says the Congress, the United States, shall guarantee to every state in the Union a Republican form of government, by the way, which doesn't mean a Republican Party form of government, it means a representative form of government, and shall protect each of them against invasion and, on application of the legislature or the executive, against domestic violence. Against domestic violence. But both of these provisions come from the founders' involvement in suppressing Shays' Rebellion, which was in western Massachusetts, which was a tax rebellion against the government, and both the state government in Massachusetts and the federal Congress wanted to act very sharply against it, to say there's not a right of insurrection, and on the contrary, the people of the state have a right to call on the resources of Congress to put down domestic violence, okay? How about this? Treason against the United States shall consist in levying war against the United States, or in adhering to their enemies or giving them aid and comfort. Okay? It's the only place in the Constitution where a crime is defined. So far from being some noble act of citizenship, insurrection, at least some kinds of insurrection, would qualify as treason by waging war against the United States, levying war against us. A corollary fallacy that we get from the so-called Second Amendment gun rights forces is that the people in armed insurrection against the government are a militia. And sometimes they formulate it like this, that anybody can form a militia, or the people can form a militia in order to overthrow a tyrannical government, okay? But look at this. Congress has the power to provide for organizing, arming, and disciplining the militia, right? Reserving in the states, the state governments, the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. In other words, the well-regulated militia, which is added to the Constitution in the Second Amendment, picks up on this intergovernmental device defined in Clause 16 of Article 1, Section 8, which maps out the relationship between Congress and the states in creating the militia, governing the militia, organizing and arming it. The Proud Boys is not the militia. The Oath Keepers is not the militia. The Ku Klux Klan is not the militia. All 50 states have laws that ban private militias. Congress should have one too, by the way, and I'm working on that. Well, here's my favorite textual refutation of the idea that the Constitution establishes a right for Marjorie Taylor Greene and Matt Gaetz to overthrow the government if they think the government is turned tyrannical. Check out Section 3 of the 14th Amendment, right, adopted in 1868. You can't be a senator or a representative, or you can't hold any office, civil or military, under the United States if you've previously taken an oath as a member of Congress or as an officer of the United States or as a member of a legislature or as an executive or judicial officer to support the Constitution, but then you engage in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. Congress maintains the power to lift that disability by 2/3. Okay, this is the clause in the Constitution that has just been litigated in the Supreme Court when the Colorado Supreme Court disqualified Donald Trump, saying he's not qualified because he swore an oath to uphold and defend the Constitution against all enemies, foreign and domestic, and yet violated the oath by engaging in insurrection or rebellion. So, I believe that the entire architecture of our Constitution defeats and refutes what they're saying about the meaning of the Second Amendment. And why is it important? It's important because that's the argument that has created the bitter partisan divide, categorical divide between the Democrats and Republicans over whether or not we can adopt things like a background check. It's also important now for us to understand what just took place in the Supreme Court about Section 3 of the 14th Amendment. Lincoln said in his first inaugural that an insurrection is a war upon the first principle of popular government, the rights of the people. And it's such an important idea to keep in mind because when, excuse me, thank you much. When January 6th happened, the insurrectionists on that day dressed themselves up in the rhetoric of populism, majoritarianism. This is the people's house. This is our house. We're just taking it back. And even if you took every single person who was at Trump's rally, and not just the people who made it into the building, you're still talking about 50,000 people, which is, less than 10% of one congressional district out of 435, right? So you got a tiny, tiny subfraction of the American people showing up, beating the hell out of our police officers, breaking their arms and legs and noses and jaws, and causing people heart attacks and strokes and so on, but donning the garb of popular democracy. But Lincoln reminds us that an insurrection's an attack on democracy. Democracy has a formal procedural structure to it that you engage in. The members who were there in joint session under the 12th Amendment, collecting electoral college votes, counting the electoral college votes, were there as an expression of constitutional democracy, popular constitutional democracy, as far as we've gotten in terms of the electoral college. So I want to just say a word about the Supreme Court's decision in the Colorado case. The Supreme Court, first of all, contrary to public mythology already, did not determine that Trump was not an insurrectionist. Neither did the Supreme Court determine that Trump did not engage in insurrection. The Supreme Court, in fact, did not touch the factual findings of the Colorado Supreme Court. What the court said was that a state does not have the power to exclude someone from the ballot on the basis of Section 3 of the 14th Amendment. Nor, the Supreme Court said, does the Supreme Court have the power to exclude somebody from the ballot under Section 3 of the 14th Amendment. Only Congress has the power. So it's a non-justiciable political question. It's a political question for Congress to decide under Section 5 of the 14th Amendment whom to disqualify on these grounds or how to do it by setting up a judicial process by which someone could be adjudicated an insurrectionist who'd actually participated in insurrection. Well, the first thing I want you to see is how narrow a principle is embodied in Section 3 of the 14th Amendment. When the radical Republicans first brought it out, people like Jonathan Bingham or Thaddeus Stevens, when they first brought it out, they wanted to go much further. They wanted to say anybody who participated in insurrection against the Union can never vote again. Anybody who participated can never vote again. And when it got over to the Senate said that's far too broad and it's too draconian a remedy. So they said, we'll take the people who are most culpable, those who were public officers in the U.S. government, who violated their oath, who've proven themselves untrustworthy, and even those people, like Jefferson Davis or Robert E. Lee or whomever, even those people, we won't disenfranchise them. They'll still have the basic building block of citizenship, the right to vote. We'll just say they can't serve in office again because they've proven themselves unworthy of the oath. So that was what was put into the final analysis. The trial of Jefferson Davis established the principle and demonstrated how taken for granted it was that an insurrectionist or a secessionist could not serve again. Davis's whole defense that he used at the suggestion of a Supreme Court justice was that it would be double jeopardy to try him again for treason when he's already been disqualified from holding office again. The court never found that and didn't agree, but just to show you how obvious that principle was at that point. And yet, in public discussion of Section 3 of the 14th Amendment, there's been a lot of conversation about how it's fundamentally unfair and undemocratic, and therefore unconstitutional, which is itself a non sequitur. But it's unfair and undemocratic to exclude Donald Trump from serving in the presidency. It's the way I heard people in the news discussing it was, well, why should he uniquely be disqualified from being president? Out of everybody in America, why should he be disqualified? Well, in fact, there are more than 100 million Americans who are disqualified for running for president. If you look at Article 2, Section 1, Clause 5, first of all, you've got to be a natural-born citizen of the United States. That's that clause that, at least allegedly, Thomas Jefferson got put into the Constitution to keep Alexander Hamilton out of the presidency. And you got to be 35 years old, right? And you can't have lived out of the country for the prior 14 years. Well, look at how many people that ends up disenfranchising. By my count, more than 75 million people, including a lot of people I serve with. I serve with a great young congressman named Maxwell Frost from Florida. He could be a great president, but he's disqualified. AOC is disqualified. She's not old enough to be president. There are millions of people who can't run for president and be president because they weren't born a U.S. citizen. They were naturalized as citizens. So my law school classmate, Jennifer Granholm, who's the Secretary of Energy, was born in Canada, so she can't be president. Arnold Schwarzenegger, who was governor of our largest state, he can't be president. You know who else can't be president? Is Barack Obama, because he's already served 2 terms, right? You think about all of the different forms of disqualification for being president, the most morally defensible is the rejection of people who've participated in insurrection and rebellion against the Union. You have chosen to put yourself in that place, and you have proven that you're not trustworthy enough to hold the office. So I don't know that it's unfair or undemocratic. It's certainly not unconstitutional to do it. I think that the Supreme Court made a huge error in its extraordinarily rare gesture of deference to Congress to say it's up to Congress to decide this. We don't want to be so arrogant as to just read the Constitution, read the language of the Constitution, and read the history of the Constitution in order to implement our ferocious originalism and textualism. In any event, it's up to Congress now, and I think as long as the Republicans hang on to their 1-vote majority in the House, I don't think we're going to be getting a mechanism to the floor of Congress. But think about it. Go back to Lincoln's statement, right? We have several hundred million people in the country. There are a lot of people, I bet there's a lot of people in this room who could make great presidents. Why do we need to go back to somebody who's already proven his fundamental disloyalty to the Constitution? At least in the eyes of the law, in the eyes of history and the Constitution, is about the most disqualified and unqualified person to be president that we've got. So do we want to adhere to the text of the Constitution and its meaning, or do we say it would be inconvenient? Or do we make a series of consequentialist arguments? People say that would be a very controversial decision. That would be a very divisive decision. Unlike, for example, the Dobbs decision, which overturned more than a half-century of women's right to choose under Roe versus Wade. It might be controversial, it might be divisive, but if it's in the Constitution, doesn't that mean we've got to abide by it? Doesn't that mean that's why we've got a Constitution? You might think that, excuse me, you might think it's unfair today that insurrectionists can't be president, change the Constitution, right? That's what the pro-Dobbs forces are saying about abortion. Forgive me. They're saying go out and get the 2/3 vote in the House, a 2/3 vote in the Senate, 3/4 of the states. Change the Constitution. I don't think there's anything clearer in the Constitution than Section 3 of the 14th Amendment. Go out and get 2/3 of the House and 2/3 of the Senate and 3/4 of the states and change that. Or don't call yourself a constitutionalist, at least. Because a constitutionalist is somebody who at least tries to be faithful to the text of the Constitution. All right, so that's what I want to close on, is the whole idea of constitutional patriotism. That do we owe our fidelity and our faith to the Constitution, or do we instead just rightfully try to twist it to whatever our political goals are, right? And of course, it's easy enough if you make the Constitution stand for whatever you want to happen to be a constitutional patriot. And so sometimes the test is whether you think the Constitution takes you places where you don't necessarily want to go. I mean, if you go back to the Second Amendment, if we got rid of the assault weapons and we did the red flag laws and we had a universal background check, that's not remotely going to put America into the same camp as the European countries or Canada. We're still going to have by far the highest rate of gun violence in the world. We've got several hundred million guns already out there. But the truth is that if you want to maintain fidelity to the Constitution, at least as it's been interpreted, you would say people have a right to a handgun and people have a right to a rifle for recreation and hunting, which is what the Supreme Court said in the Heller case. So you might want to go further than that, but either you've got to change the Constitution or you've got to explain why their constitutional interpretation is wrong. But you shouldn't be misstating what the Constitution says and the clear structure of the Constitution, nor should you be misstating what the Supreme Court has said in order to try to gin up a culture war in the country or to support the weapons manufacturers. That strikes me as fundamentally constitutionally unpatriotic to do it like that. So we got to read the Constitution, we got to study the Constitution, we got to debate the Constitution, we got to teach the Constitution, and we also have to look for constitutional meaning in the history of the country and look for the history of the country in the Constitution. If you read the Constitution the way I do, the vast majority of the amendments that we've added since the original Bill of Rights have been pro-democracy, suffrage extending, democracy deepening amendments. So the 13th Amendment abolishes slavery. The 14th Amendment gives us equal protection and due process. The 15th Amendment bans race discrimination in voting. The 17th Amendment shifts the mode of election of the U.S. senators from the legislatures to the people. The 19th Amendment doubles the franchise in America by giving women the right to vote. The 23rd Amendment gave people in Washington, D.C. the right to participate at least in presidential elections. The 24th Amendment banned poll taxes in our elections, and the 26th Amendment lowered the voting age to 18. The whole trajectory of American history has been towards greater democracy, a more perfect union by including people who had been made invisible or marginal by virtue of political arrangements. So, to me, constitutional patriotism requires being loyal to that historical dynamic and also understanding what Tocqueville said about democracy in America, where he said that democracy and voting rights in our country, he said, are always either shrinking and shriveling away or they're growing and expanding. And we've obviously been very much in a contractionary mode towards voting rights with all the voter suppression tactics and the gerrymandering of our districts and the dismantling by the Supreme Court of the Voting Rights Act in Shelby County versus Holder in 2013. All of these attacks on the right to vote, and we've got to get back on the growth track. That, to me, is at the heart of constitutional patriotism today. It's 2024. How about we elect the President of the United States the same way we elect governors and representatives and senators and mayors and everybody else? Whoever gets the most votes wins. How about that? Can we? So we've had 5 popular vote losers become president in our history, twice in this century alone, in 2000 and 2016. The Electoral College these days can get you killed, as we saw on January 6, 2021. It marginalizes the vast majority of Americans who live in safe blue states, like your fine state of New York or California, or safe red states, like Alabama or Mississippi or Texas. And everybody knows it comes down to a handful of swing states. And they're not swing states because they're representative or they're big or they're small. They're swing states because they happen to have relatively equal numbers of Democrats and Republicans in there. And we spend hundreds of millions of dollars a year all over the world exporting American democracy and electoral institutions. And the one thing they never come back to us with is, you know that Electoral College thing you've got? We think we'll import that to our new democracy. So I think a constitutional patriot today is in a tough position because you got to play defense and offense. On January 6, 2021, you got to play defense and defend the Electoral College against violent insurrectionism and traitorous appeals to Vice President Pence to step outside of his assigned constitutional role, which is a ministerial and administrative role, simply to proclaim Donald Trump the President of the United States, or to falsely kick the whole contest over into the House of Representatives for a so-called contingent election under the 12th Amendment. You've got to defend the Electoral College against those who would trash it in pursuit of dictatorship or some other form of government, at the same time that we have got to be looking at the Electoral College as one of those relics like state legislative control over U.S. senators or the disenfranchisement of women. So these days, I think, but now here I'll step out of the scrupulously nonpartisan academic talk I've been giving you, but that a constitutional patriot can't be averse to party politics if that's what it takes to defend the Constitution and to defend the government. I'll close with that thought, and I'll open it up for your questions. And thank you for allowing me to do this. I don't get to do a lot of lectures anymore. My speeches are usually confined to 1 minute on the House floor. And so I'm sorry it was so disorganized, but I think you get the gist of where I'm going. So thank you very much.
Okay. Our Manhattan College tradition is to start with a student. So a student with a question, we shall start with you. We will wait. Okay. Thank you.
If you give me a seating chart, I'll start calling on them too. So.
Hi. My question is, how do you think it can positively increase constitutional understanding for younger audiences, especially with states getting votes in educational content?
Well, yeah, that question is close to my heart because, just like they say that, war is too important to be left to the generals, the Constitution's way too important to be left to the Supreme Court or, the constitutional law departments. I mean, it really should be, when I was in academia, I created a project called the Marshall Brennan Constitutional Literacy Project, where we're sending law students into public high schools to teach the Constitution. And that book that I wrote, We the Students, is all about the Supreme Court cases that affect kids in public schools, like locker searches, drug testing, censorship of newspapers and yearbooks, school prayer, all that stuff. And So you can make it the most fascinating class in the world. It's not remotely boring. I mean, there's a million things that kids have very strong feelings about that you can teach them about it. And so I don't know how we lost the whole civics thing. It may have something to do with like the testing orthodoxy, but I don't know. But so I think that we need lots of civil society efforts to do what you're talking about. And then we've got to infuse our political conversation with constitutional argumentation. And at least the people who are promoting all the constitutional fallacies, they do that, but they do it in a way to confuse people and to lie to people about what the Constitution says. So I've challenged all my Republican colleagues. I say, I will debate any of you guys anytime you want about the Second Amendment or the First Amendment or, I mean, another fallacy, we don't have time to get into it, but it's very much out there, is that America's a Christian nation and that it's set up as a Christian nation. And obviously that's at direct odds with the Constitution, which is the only Constitution on earth, or certainly was when it was written, that didn't mention the word God, and said no establishment of religion, free exercise of religion, no religious tests for public office. And that's been such an important source of the strength of our country. I mean, it was really the genius insight. And, I hear my colleagues, Mike Johnson, the Speaker of the House, will get up and say, the moral downfall of America was in 1962 in Engel versus Vitale, which is a case out of New York, where he says that the Supreme Court banned prayer in the public schools. And I always get up and I say, the Supreme Court never banned prayer in the public schools. As long as there are pop math quizzes, there will be prayer in the public schools, right? Anybody can pray whenever he or she wants to pray. It's just the government can't compose a script and compel you to participate in it, So anyway, if we're not teaching kids about the Constitution and what it really says and about our constitutional history, it's because we're afraid of them becoming strong citizens. And there are people that are promoting constitutional illiteracy and demolishing critical thinking skills in the country. Thank you.
I think I can be heard. I must admit that I love your line that we live under Canada. I will quote you on that.
Certainly in New York, you guys do.
So that's true. I'm not a lawyer, but I've just loved con law since I was an 11th grader. And so you raised about a half a dozen questions in my mind, but I'll limit myself to one. You talk about the Second Amendment, which I thought was a failure only due to a misplaced comma. But I do think that the Second Amendment was intended to give citizens the right to defend their homes against an overzealous government. Not go outside. So you can have all the weapons you want in your house, but once you leave the house, the government has the right to protect the marketplace and special places, etc., against the damage that you could create. But my question for you is, one thing I haven't really understood is, under, I think it's called the National Defense Act, you can't own a tank, you can't own a grenade launcher, you can't own a RPG, etc., 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 and you can't own an automatic weapon.
Machine gun, yeah.
Machine gun. So I'm a little confused about the delineation that is created. If we are allowed under the National Defense Act, which is I think 1940s,
right,
to prevent people from having bizarre, very dangerous weapons,
right.
Why can't we limit semi-automatic?
Well, I would agree with that. The thing is that the NRA and those forces have not yet challenged the ban on tanks and machine guns, and you can see where my colleagues are going. They would clearly find that, yeah, if you can afford a tank, then you can own a tank. But remember, the NRA for a long time didn't want to, because they were afraid that they would just get a re-articulation of standard Second Amendment doctrine going back to the beginning of the Republic, which is it is not a right that an individual has against anybody, much less against the government, right? That it's connected to militia service because of the well-regulated militia clause. They didn't want to challenge it until they packed the court And then suddenly, they knew that they would be able to change the jurisprudence and change the doctrine. And that's what happened to us there. So when you say you're puzzled that we've accepted this for so long, I mean, Heller versus District of Columbia absolutely turned on its head 2 centuries of understanding of what the Second Amendment was. I think it's going to be very hard to dislodge that basic framework, but what we can rightfully use is all of Scalia's exceptions, which are exceptions in the interest of public safety and public welfare. And that's what my right-wing colleagues refuse to concede, that under current black-letter law, constitutional doctrine, we can pass all of the things that the American people want. And they would prefer to continue to spread the fear, oh, if we allow red flag laws, if we ban assault weapons, then they're going to confiscate every gun in the country, which we can't do. Nobody wants to do, but we can't do anyway under Heller. Yeah. Thank you much.
So if you look at what Trump and a lot of his advisors in the Federalist Society and things like that are planning on doing if they get elected in 2024 and take office in 2025, I think it's called Project 2025.
Yes.
Looking at that, in the event of a second Trump presidency, God forbid, what can we do to make it so that executive power, makes all of the second half of the presentation here move basically, because everything would be protected if everything the president does would be illegal and things of that sort. What can we do as unelected people to prevent that?
So it's a great question. I'm glad you're asking that question, although it's a hypothetical I would prefer not to entertain, or at least to maintain at the hypothetical level. It's just unthinkable that we would go back to that situation. This is what constitutional patriotism is all about. I'm glad, that I've had colleagues like Liz Cheney and Adam Kinzinger and Mitt Romney, and people are willing to stand up for the rule of law and democracy, even, they're in the same party as Donald Trump. Conventionally, the great thing about the separation of powers, both vertically between the states and the localities and the federal government, and horizontally in the different branches, is that if one branch is captured by a tyrant or a would-be monarch or what have you, then there are other branches and other places in the government that can act. And so it's an all-hands-on-deck moment where we need people acting at every level of government to stand up for strong democracy and for freedom. But I would say that, all of those questions you're asking about what could be done are better left to the side right now to get everybody engaged in the process of trying to defend the electoral educating and mobilizing other young people to be engaged in the election in a powerful way.
So, my understanding of the constitutional history of the Second Amendment was that militia was very narrowly defined and was proposed, that amendment was proposed by the slaveholding members so that militias could be organized to put down slave rebellions. Even a more narrow view. Does Is that?
Yeah, Carl Bogus from Roger Williams Law School has written some very good articles on that, saying that the Second Amendment, like the 3/5 clause and other provisions that explicitly endorse slavery, at least for a temporary period in our history, was really about protecting the slave power and not allowing the federal government to disarm local militias and police forces that were used for the purposes of putting down slave rebellions and policing the enslaved people. And there's a big historical fight, about that question. I don't know that whether that's going to be fundamentally soluble, but in any event, it's very clear. I think that the liberals in Heller had a strong argument that it really was about the protection of the police power. It, of course, endorses that history, that it was really about allowing a local police power to exist. You don't want to follow that kind of originalism too closely, because then it's basically about the protection of racist local police forces, although that was clearly transformed by the Civil War and the 13th and 14th Amendments. I'm quite persuaded by what he had to say about that. But it's not that relevant to resolving the problem that we're dealing with today. It goes to the question of why there were local militias to begin with, And there were clearly militias that existed for other purposes, like participating in the American Revolution. They weren't super successful, which is why, George Washington created the Army and so on. But in any event, the liberals kind of lost that fight in Heller, and now that's why I'm saying, okay, let's agree to what Scalia said, at least with respect to public safety and public welfare.
What do you think about term limits for the Supreme Court?
I like the idea of term limits for the Supreme Court. For one thing, when the country started, life expectancy in the country was in the 50s. Brett Kavanaugh could be on the court for like 80 years or something, They don't have very physically taxing jobs. It's not like being on an assembly line or something, and so that's one thing. We have a very arbitrary and kind of casino-like approach to who gets on the Supreme Court. I don't know how popular this point's going to be, but we've got 13 federal circuits in America. We have 9 justices right now. I'm for going to 13 justices, and there's got to be one from each circuit. Now, New York City actually has 5 justices on the court, one for each borough, okay? And that might work great for people in New York, and I understand you've got great lawyers here, but there's something very odd about that. So I like a system where each president would get the appointment of 2 justices, guaranteed, which would reduce a lot of the partisan warfare, right, if each president got 2 and just 2. There's one from each federal circuit, so they've got to go to that circuit if that's their turn. And then they've got an 18-year term so that they rotate off. Now, the Constitution calls for life tenure, but it doesn't have to be life tenure in the Supreme Court. So in other words, they could rotate off the Supreme Court and then become a circuit judge or a district court judge, and that would conform to the life tenure protection in the Constitution. So I'm all for that. I think we should absolutely discuss that. And what's happened with the Supreme Court, whose ratings are like even lower than Congress's, has been just shameful, disgraceful. The corruption, the overt partisan politicization, the sandbagging of my constituent, Merrick Garland, who was the chief judge on the D.C. Circuit Court of Appeals, would have been one of the most qualified people ever to go on the Supreme Court, and he didn't even get a hearing when President Obama nominated him in February of 2016, when Justice Scalia died. And then in October, or maybe it was end of September 2020, when Justice Ginsburg died, and everybody said to McConnell, well, you're not going to do this 2 months before the election. You wouldn't have hearings 11 months before the election. And he just laughed it off. And he said, oh, well, that's because they had the president then. And then they barreled through the nomination of Mrs. Waterford, or whatever her name is. So, yeah.
So I was interested in what you were saying about how the Constitution can be, sort of twisted or used to achieve political purposes. And I mean, I've seen a lot of that in the last couple of years. For example, like with the impeachment trial of Alejandro Mayorkas, or Trump is accusing, you said, Merrick Garland of weaponizing the Justice Department. How do you see in the next couple of years, is it at all possible that that sort of trend stops and we start going back to like the constitutional patriotism and defending it?
I mean, I don't want to give an overly romantic view of our past. I know the great historians in this room would, say that the Supreme Court's always been embroiled in conflict. And when it hasn't been, like for the first century of our history, it's generally been on the side of racism or slavery or apartheid. And so I think we got a little bit fall out of love with the Supreme Court. I mean, there was that brief period in the Warren Court where you got cases like Roe versus Wade and Brown versus Board of Education and Miranda versus Arizona. But for most of our history, it's been, Dred Scott decision and Plessy v. Ferguson and Shaw versus Reno and Miller versus Johnson. And the court is basically, people are saying, can you believe how reactionary the court is today? Yeah, I can believe it. It's retreated to the historic baseline that it started in. It's been a profoundly conservative or reactionary institution for most of our lives. So, I put my faith in popular constitutionalism. I put my faith in the ability of the people to read the Constitution, understand the Constitution, and fight for the Constitution. So, I think they all got it wrong in the Colorado case about Section 3 of the 14th Amendment, including the liberals. I went to the oral argument, and I saw, which justice was it? I think it was Kagan. Yeah, I think it was Kagan who said, well, Justice Kagan said, well, if they couldn't keep an insurrectionist off the ballot, even if they knew he did it, even if he participated in insurrection, because you couldn't have one state deciding who would be on the ballot in a presidential election. And I'm like, and I went to law school with Justice Kagan. I like her very much. I think she's generally a great justice. But I'm like, good morning, Justice Kagan. That's how our electoral system works, right? I guarantee you that the New York presidential ballot will be completely different from the New Jersey presidential ballot, or the Florida, or the Texas. Each state decides for itself who goes on the ballot, right? And so we're saying we're going to allow them to decide, one state you need 100,000 signatures to get on, in the other state you need one signature to get on. In some states it's really easy for a third-party candidate, in some states it's really hard for a third-party candidate, and so on. But you can't even do your own thing as a state in order to enforce the meaning of the Constitution itself. That strikes me as just bizarre. So, but that's why I say, the Supreme Court doesn't own the Constitution. Even if they've got a 9-0 decision, I can still say I dissent. I don't think you guys got it right. And I think that the Constitution does place upon us a responsibility to make coherent arguments based on language, text, history, structure, ethos, precedent, and so on. There are certain tools that we use in the process of interpreting the Constitution, but it shouldn't just be, I want it to come out a particular way because it agrees with my politics, or it'll be a lot easier for the court if we don't deal with it, for example. Yeah.
We'll do a few more.
Thank you very much. That was the first feedback I've gotten on it, so I appreciate that. Some of you might have to be here. I don't know what the orders are in the classes.
So, if the majority of Americans are in favor of common sense gun regulation, and yet profound constitutional arguments aren't working, and profound tragic events like Sandy Hook aren't working, how do we push through? Do we just wait out Congress, or how do we push through to have these common sense regulations happen?
Well, I mean, the primary answer is elections, but what happens, you're saying, I think, when elections aren't enough, right? And that's why I feel very strongly about engaging in this conversation about the Second Amendment or any of the other things that we could be talking about in terms of constitutional fallacies today. Because unlike some of my other colleagues on the Democratic side of the aisle, I actually listen really carefully to what the Republicans are saying, right? I mean, I don't know how many people in America know that the reason why we're not getting anything done is because this is the dogma, at least the self-justifying dogma. I mean, maybe some people say, well, it's just NRA contributions or it's just the weapons, the gun manufacturers. But in any event, they have created this pseudo-constitutional rationale for inaction, and at least we need to debunk that to say, as I say to them every time, don't pin it on the Constitution. The Constitution's not stopping you. You know, sometimes they say, Raskin wants us to repeal the Constitution. They want us to repeal the Second Amendment. I say, I don't want you to repeal the Second Amendment. I want you to read the Second Amendment, okay? That's all I'm asking. And let's have an honest conversation about what's in there. Like, be that patriotic towards the Constitution, at least to read it and try to understand it. So, you know, it's tough times, but we've got to take elections seriously as partisans, and then, you know, in the interval between elections, we've got to do what we can to make dialogue work.
Sure, good to see you. Healthy and eloquent.
Thank you kindly.
Is our constitutional architecture itself, do you think it's an Achilles heel? I mean, the Electoral College, for example, in states to ratify, I mean, why would the lesser populated 25 vote themselves out of the question, essentially? Or, you know what I mean, that, you know, they sort of sacrificing leverage. Just the thought.
Yeah, well, I've actually been very deeply involved in this question. When I was a state senator, the very first bill I introduced was for the National Popular Vote Interstate Compact, which is a way to get to a national popular vote short of amending the Constitution. And basically, the device is we've created an interstate compact, which we have the power to do. The states get together and we say, we'll cast our electoral college votes for the winner of the national vote rather than the winner in our state. And once we have 270 electors, at least, represented in the coalition, it'll work every time. And if we do it for one or two cycles, at least I asserted and I assert, then we will go ahead and amend the Constitution. If you look at like all those amendments I was talking about before where we've opened the Constitution up, you had enfranchised people enfranchising disenfranchised people. Well, why would the half of the country that's men give women the right to vote? Well, it's not just out of the goodness of their hearts, right? It's not just that they knew women and so on, but a majority of the states had already at that point decided to give women the right to vote. And why did we go from the state legislatures choosing senators to the people? A majority of the state legislatures said, we're going to be bound by the popular vote in our state. And so the constitutional amendment was kind of like ratifying a fait accompli constitutionally or politically in the country. And I think it's the same thing here. If we get enough states together to say, we're all going to jump together, we want a popular vote, we'll be bound by the popular vote, and we can do it this way, and we show it works, at that point, the constitutional amendment would be kind of like the icing on the cake, or like changing it to the changing of the guard in Buckingham Palace. Like the Electoral College, it it's still going to exist until we amend the Constitution, but it'll exist as a formality, right? And then when we see we don't need it anymore, then we've grown past it. So I just think it's so much in the mainstream of our constitutional development to go from an anti-democratic filtering device created at a time when we didn't even have a constitutional right to vote in the country, and most people couldn't vote in the country, to where we are today and where we want to go. But that's why I'm with John Dewey, who said that the only cure to the ills of democracy is more democracy. And what we're suffering from today is not democracy, but it's the continuing blockages and impediments to it.
Okay, so drinks and hors d'oeuvres are waiting for us. So thank you so much for this talk. I invite everyone to join us in the back. So thank you.
Thanks so much.
Thanks. Yeah. We got more questions, but go into the food.
Yes, hi. Oh, thank you. Thank you. Thank you for